all right. The Ulfas and the Bodos and Assam want more rights. They don't want a separate state. It's a big movement forward, thanks to the nature of CI operations. But the Maoists and the Naxals in India, they have declared their aim as the elimination of the Indian state as it exists, as a secular democracy. So within India, insurgencies are of different types. Therefore, keeping in mind the fact that CI ops do not justify collateral damage. A drone can kill a Talibani leader, but also kill 25 women and children. That is considered acceptable. In the armed forces, that is not acceptable in India. So, talking about ethics, which is the subject given by those who organized this very timely conference, it is a moral philosophy which involves systemizing, defending, and recommending concepts of right and wrong. These are rules or standards governing the conduct of a human person or members of a profession. There are two questions asked today. You must introduce tough ethical powers, which assumes that there are no ethical orders existing, that Indian armed forces are functioning without ethical directions. Second, that if there are such rules, they are not being imposed or applied strongly enough. But there is another question, which I leave it to this very lively young population, which must be asked. Why is it necessary in a liberal democracy to use the armed forces, particularly since the total number of police, paramilitary, special armed police are larger in number than your army, navy, and air force? Why does a democracy need army to be applied against its people? When there is every corner here, you see a policeman with a weapon. You must ask that question. The army has been in CI operations for 50 years. Some of us, like General Nambia, or me, or the general who is KK area commander, we went to Northeast when we were lieutenants. And we have continued going there till we became lieutenant generals. There's something wrong in policy somewhere. That's not our job, to fight our own citizens. That question is never asked, and I'll tell you why it has happened. Why is the army continuously being used? The question to be debated is as much as whether there is ethics in the armed forces doctrines and laws, but why is the army required in the first instance? One is because, for right or wrong, our policies have not produced distributive justice. There are large sections of our people who feel they don't have the rights or they don't get what they should get. Second, and the most important question is that as a matter of policy, political establishments all over the country have disabled the police structures and culture by wrong policies, by wrong recruitment, by wrong technology. With the result that you cannot expect the police to do this job, even though they have weapons. So at the first bomb going off, get the army. The army has a doctrine of subconventional operation called DOSCO. The Army's operations are legally enabled by the Armed Forces Special Powers Act, which I know will be discussed today. Even a constable in Nagarbavi, if he wants to arrest you, he must have a warrant. How can the army go and fire at a man who is pointing a gun at him without legal authority? AFSPA doesn't. What is our experience in this? Algeria, Vietnam, Malaya, a major example on which textbooks are written. These operations can last for years if not handled properly. And we haven't handled them properly. Not the Army, Navy, Air Force, but the leadership of the country which negotiates with them. Military is not the answer to insurgency. There's a famous French writer called David Galula, who was an Algerian, who was a Christian, who conducted such operations in the Algerian country when Algeria was part of the French Empire and fought for freedom. And from the desperate fighting they did, he wrote a brilliant book. And there is an interesting quote in that. He says, and I quote, "In a fight between a fly," you know what's a fly? In a fight between a fly and a lion, the fly cannot deliver a knockout blow, and the lion cannot fly. So the conflict will go on, one biting the other. And he recommends concentrating on not defeating the insurgent, but on the population and its aspirations, instead of purely military action. So counterinsurgency is not purely military action. It has to be political action, social action, economic action, empowerment, health and education, everything. So this debate which looks at counterinsurgency operation, I may be wrong, but it gives me the impression that it is looking at counterinsurgency operation as the solution to insurgency. It's not the solution. It's a socio-political campaign. And it took Iraq and Afghanistan for the major powers to realize these facts, that population should be the center of your gravity. So General Petraeus, who was hailed as a great guru, or there is a British general called Rupert Smith, who wrote a truly classic book only a few years ago called The Utility of Force. They have said, make population the objective, not the target, and you will win this war. They are recommending today what the Indian Armed Forces have been practicing since 1947. So what is the doctrine that we have? In a journal published from UK called Small Wars Journal, it has listed some countries which have the best practices in counterinsurgents. And it has placed the Indian Armed Forces on top of that list. What are the Indian Armed Forces goals? First, political goals should be the primary aim, not military victory. Political goal. Are you getting a political outcome which will give you peace? Population and not the insurgents should be the center of gravity. Give them home, give them jobs, give them political rights, and they will not be insurgents. There should be unity of effort. Army cannot do it. The civilian authority, the collector, the DG police, the cabinet of the state, everybody will have to cooperate in this operation. It's not a military problem. So we should be united. And above all, there should be rule of law. If the defense forces themselves violate law, then they have no case. It's not as if we have not violated law, but we have not violated law as policy. There are individuals who have conducted excesses, have done terrible wrong things. We own up. Army is the one institution which will punish them. Not in the civilian, you can have any amount of corruption, it will all go under the carpet. Having said that, the AFSPA will be discussed, no doubt. Let me just say that it's an enabling act which enables the army, when under this act, when asked by the government, to take military action against those who are conducting military action. This act doesn't allow me to take a gun and go in anybody's house and shoot. I'll be court-martialed for it. I must remind you before the debate starts, it's an act of parliament passed by the Lok Sabha. Army has not passed this law. If the Lok Sabha removes the act, we'll go out very gladly, singing Sare Jahan Se Acha. We don't want to do this job. There are states, let me not name them, where governments, when in power, want the act, and the same party, when in opposition, opposes the act. I was part of a government-appointed commission headed by a former judge of the Supreme Court to look at the Armed Forces Special Powers. The only question I asked everywhere in Northeast was, you want the act to go? Well, if the act goes, we will also go. They say, no, General, we want the army here, but we don't like the act. Can't have the cake and eat it. So the AFSPA is not the cause of insurgency. And nor is the continuing insurgency the consequence of the act. There are other reasons. So there are two sides of the debate, and I hope both sides will discuss. I was struck by the Chief Justice of India, Altamis Kabir, who said last week, after the gruesome rape case and the huge debate where people want every kind of thing, bury him alive, castrate him, this, that, and the other, the debate has lost focus. And the Chief Justice of India had done a great service by saying, quote him, avoid the blame game, go to the causes. So here also in this debate, let's avoid the blame game, go to the causes of insurgency. Sardar Patel in 1949, 1 year after independence, called the Director General of Police of all Indian states and said, it will be a serious mistake if you call the army again and again. Let them do their job. Keep the standards of police high so that they can do the counterinsurgency. 49, it is 2012. Little has changed. Debate that. Thank you for your attention.
Thank you for those remarks. And it's especially powerful considering the profound effect it has of quelling some of our biases, especially considering the flawed assumptions we might be making about the context. And it really helped for us to clarify some of these things. And to briefly summarize some of the arguments that Sir was forwarding today, we have four or five key ideas, right? The first one is about the idea of distinguishing the conditions for entering into war and the standards which you should maintain once you enter into war. The second idea was about the need for the involvement of the army to solve what is essentially or possibly just a political problem. And thirdly, the importance of talking about the idea of the existence of rules and the application of rules, by which Sir was implying that individual incursions are really the exception and not the norm on which the act operates or the way the army operates. And more importantly, the idea of how it can be contrasted, how the Indian situation really can be contrasted from other circumstances of insurgencies, which really don't work on the same kind of premises that the Indian conflict has, which really requires us to address it in a unique manner that hasn't been done before. And we are extremely glad that this is happening for the first time in the history of this sort of engagement. Without further ado, I request all of you to kindly turn off your mobile phones. I call this House to order. I'd like to invite the first speaker from Proposition, Mr. A.G. Noorani, to open the case for a side proposition.
I have this pleasure for two reasons. One is my innate laziness, and the second is I have not come here to speechify. I have come here to chat with you, talk to you, and believe me, is what I said to the Vice Chancellor and to my colleagues when we were discussing. Nothing inspires me more than the presence of the young whenever I'm invited to speak. The clear eyes of youth. Our generation has muddled, added, inflicted grave wrongs. You are our hope. And when I speak to the young, I learn much more from them than I could possibly learn from you. Let me come straight to the point. It's about the Armed Forces Special Powers Act. I was rather surprised to hear General Raghavan say, it's not the army which made the law, it was made by Parliament. Yes, sir, but nobody has, in his senses, would suggest that the army has the power of legislation. Thank God it doesn't. But as far as Parliament's legislation is concerned, the Parliament which passed the Armed Forces Special Powers Act could not have done it in a vacuum. The minister who piloted it must have been egged on by the armed forces. And the Parliament which had passed that law is also the Parliament which passed the Preventive Detention Act. And there was a time when Sardar Patel said, I had a sleepless night, that was in 1950, when he piloted this Preventive Detention Act on a Sunday. That was the outlook in those days. What happened? Tada, Pota, and all three laws have been upheld by the Supreme Court. Now, it was said of Liversidge versus Anderson during the war, when Lord Atkin dissented, the question was, if the Secretary of State has reason to believe that the person is acting in such a way, he shall detain him. 4 judges said it's a subjective opinion. Lord Atkin dissented. Today his dissent is law. The majority judgment is ridiculed and has been aptly called the House of Lords' contribution to the war effort. In such cases, I'm sorry to say, the judges become ultra-patriotic. And you find expressions in our judgments which you don't find elsewhere. Having gone through the Supreme Court judgments, I find a glaring contrast between their approach and that of the House of Lords. Our judges don't consult those judgments. Remember, Britain has had a worse form of internal insurgency than we have had, and they were much more sophisticated, the Irish rebels. They all but killed Margaret Thatcher when she was attending a party conference. Canadian Supreme Court judgment. Please read the erudition. And what about the erudition of our Supreme Court judgment? This is what brings me to this case, Naga People's Movement versus Union of India, 1998, 2 Supreme Court cases, 109, delivered on 27/9/1997. It's a scandalous omission when a Supreme Court judgment given unanimously, including the great human rights champion Justice J.S. Verma, deliver a judgment affecting the citizen's life without referring to the constitutional guarantee of the right to life, Article 21. In my respectful submission, a judgment which omits any reference to Article 21 stands self-condemned. Let me remind you of the contrast. Section 130, subsection 3 of the Criminal Procedure Code says, as little force as necessary. What does Section 4A of SPA do? It uses an expression unknown to legislative parlance. This expression is a license to kill, even to the causing of death. Where is this necessary? Why is this necessary at all, I ask? Even to the causing of death. What are the comparative regulations? Necessary. If it is necessary to do so. If it is reasonable. Secondly, clause B. You can blow up a house. And in Kashmir, the repression has been much worse then in Punjab, an entire houses have been broken up just to get at one militant. Gentlemen, let me tell you that I do not for a moment question the proposition. I endorse the proposition. I believe the best should not be made the enemy of good. And those codes that have been made are very wise, very salutary, very constructive. But it is my humble submission that if the law itself is defective, please cure the parent before you impart education to the child. This brings me to the several provisions in British law and the Irish thing, and the judgments as early as 1893 in the Featherstone Report. That was a case of insurgency. Lord Widgery's judgment on the London Dairy thing in Northern Ireland, Lord Diplock's judgment, none of which has been considered. And finally, the European Court of Human Rights, whose judgments have been quoted by the Supreme Court, itself held that the test is absolute necessity. Absolute necessity. This expression, even to the causing of death, is absolutely unheard of. And let me confide in you, and I'm not quoting the source, in November 2009, I was informed by a very high source in the Home Ministry that amendments are pending before the Cabinet. They're being resisted by the Army. So the Army need not make the law. The Army calls the shots. And our Defense Minister will not annoy the Army. The result is that those amendments, they must be moderate amendments, they're pending. So I suggest public opinion should be built up on a two-pronged thing for those very salutary directives for the reforms and support the motion. And the strict code of ethics is necessary, but above all, let us repeal the Act. Thank you very much.
Thank you, sir. It was an absolute pleasure, as always, to hear from you. Mr. Noorani came up with the idea that there are some forms of lobbying or vested interests which are not directly represented by just legislations and popular sovereignty. And the army might have had a hand to play in the way the Armed Forces Special Powers Act itself is organized. The second idea that he discussed were the standards established by the Act, and not merely the idea that it establishes a standard which is completely unheard of in the manner of dealing with similar operations elsewhere, but even beyond what could reasonably be presumed of any armed force anywhere in the world. So to start from the opposition side, we have Mr. Neelendra Kumar to begin the speech.
The distinguished speaker who has started this debate, he basically confined himself to the Armed Forces Special Powers Act. Since not much was said about the code of ethics, I would confine myself to the Armed Forces Special Power Act. And particularly, he mentioned about the judgment of the 5 judges bench not talking about Article 21. Well, that's factually incorrect, because I do find here, I have a copy of the judgment in para 16 talking about Article 21. But leaving that apart, now talking about that do away with the right to death. Well, I can only comment that it reminds me of a situation, say of a cricket match. You got to frame the rules. You say that it will not be a 20-over match, will not be a 50-over match, will not be a 5-day match, an indefinite match, and one of the sides will not be allowed to put on pads and the helmet. Not only that, they will not have the protection of pads and helmet. They will not be allowed to hit 4s and 6s. Now, that's what is this argument about. I would like to tell you that right though at the outset we got the independence by peaceful means, but Steadily from thereafter, India has been drawn into conflict situations against our neighbors, and we have not yet come out of it. Now, the preamble to the Constitution of India, when it talks about justice, equality, liberty, fraternity, it also in the same breath talks about a solemn resolve to secure unity and integrity of the nation. I would also take you to the emergency provisions, not today, of the same time when we were talking about Sardar Patel 1949. At that point of time, we had emergency provisions in the Constitution, and one of the planks on which emergency provisions get attracted relates to internal disorder, rebellion. So at that point of time, the framers had thought that there could well be a situation that the states could, or a part of the population could have certain aspirations which they feel have not been met, and a situation not resorting to confining to democratic means could take a situation where law and order problems could worsen and a situation of rebellion could come in. And it was because of this situation that we had the Armed Forces Special Powers Act that was brought in, and 58 when the act was brought in, and its counterpart which is there in J&K in 1990, you may wish to appreciate that there have been countless governments, Congress as well as non-Congress. No one has thought of repealing the act. I am sure that these governments were not being dictated or were not being